I'm going to speak about the final argument after all the evidence is in, either through witnesses or through the filed evidence. And the essence of what I'm going to say has equal application in chambers or in trial or on appeal, although I'll use the trial context from time to time today when I talk. Now, you stand up and you're at the podium, and as I say, all the evidence is in, and then what? I mean, how do you maximize the chance of winning from then on? Simplicity is crucial, and structure is crucial. I'll talk later a little bit about flexibility, which is an overlay, but it's crucial to keep it simple and structured. So you stand up at the start of the closing argument, whether you're going first or going second, and you tell the court that you're going to speak to three issues, two or three issues. You're then going to tell the court what each of those issues is. And then you're going to tell the court what your position is on each of those issues, what you want the court to find on each of those issues. And the whole time you're talking, you're keeping an eye on the court to see if they're writing, if they're focused, and you do what you can to cause them to write. Sometimes I'll give you my 2 cents worth on that, perhaps later on. But you're seeing how engaged the court is. If they're writing, of course, you wait for them to stop writing so they're ready to hear more from you. So you've introduced the issues, and you turn to the first issue. And when you turn to the first issue, you say to the court, justices or justice, this first issue arises in the following way. I mean, that's your entree to the facts. And that's all you talk about for the next little while are the facts on the first issue. You set out the relevant facts. You set out the facts that are needed if you're the plaintiff or the applicant. You set out the facts that are needed to prove the legal proposition that you need to go home in first place. And always, always, always tell the facts in chronological order. And for a couple of reasons, as you know, or as you'll find if you think about it a bit, for some reason, our brains prefer to hear events in the sequence in which they occurred. That's the way we're wired. And equally important and somewhat related is that a key fact in a case oftentimes will only make sense if it is seen, if it is heard in the context of the facts that preceded it. So chronology is the first guide. If any of the facts that you're telling the court about on this first issue, if any of those facts are in dispute, go to the evidence on the fact that's in dispute. The corollary of that is don't go to the evidence on the facts that aren't in dispute. It's a waste of everybody's time, and it bogs the case down. You, as I said before, you'll run with the facts that are needed to prove the elements of your case, and you'll move from fact one to the next fact, and then you get to a fact which is a sticking point. And that is, it's in dispute. There's a fight about it. And it's then and then only that you'll go to the evidence. And when you go to the evidence, you go there. And what I mean is, for example, you have the document in your hand that is the key document to resolve that factual dispute. And you will have handed up a condensed book, probably, of the key documents in the case. And you say, Justice, I ask you to go to tab 15 of the condensed book, and I ask you to go to page 4, and I ask you to go to paragraph 3. Let's look at that. bam, 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 bam. And it sets out a proposition of fact, a proposition in the evidence that supports your fact. Similarly, when you're in an evidentiary fight on a particular fact that you need to prove, if you've got transcript evidence from the discoveries that have been transcribed into the trial, or cross-examination on an affidavit, or a key paragraph in an affidavit, you've got that in the condensed book as well. And you take the court to that tab in your condensed book and you read the key 5 questions and answers. And so at the end of this little exercise, there's precious little room for debate about what that fact is. If it comes up again when the other side has spoken, you may deal with it again in reply, or rather in rebuttal. But that's that. To park that fact based on your evidence, go to the next fact.